That's the concern that I've got, is that you don't seem to condemn the divisiveness if it's on the left. I want to go back briefly to the text of Section 1507. Section 1507 is pretty darn clear. I personally don't see how anyone could protest outside the home of a Supreme Court justice, especially while engaging in issue advocacy related to a case that they've taken or are currently hearing. It doesn't violate 18 U.S.C. Section 1507. So the fact that you've put U.S. Marshal Service in charge of protecting their homes, great. The fact that not a single arrest has been made, not a single set of charges have been made, is very disconcerting, as is the fact that even if the marshals don't choose to make an arrest there, which is stunning to me that they haven't, but even if they hadn't, there's video footage. You can identify folks. You've proven your ability to do that, and the fact that you're not bringing that is deeply disturbing to me, as it was when, on the day of the Dobbs decision, the Department of Justice took what I believe was a pretty unprecedented step of issuing a scathing statement, not just saying we disagree or we're disappointed with the outcome, but making arguments that I believe called into question the legitimacy of the court. I have never seen the Department of Justice do that. It is cause for additional concern when I see people like Philip Formes, having received clemency, is now having to face the prospect of being prosecuted again after having received clemency by a prior president. Add all this up with the fact that by the end of this year, we're going to see the expiration of Section 702 of the Foreign Intelligence Surveillance Act. The department's already asking and chomping at the bit to be asking us to simply reauthorize that, notwithstanding the fact that there are all kinds of examples of how this has been politicized, how Section 702 has been misused. The current standard for a warrantless backdoor search of the content of communications of American persons is reasonably likely to return evidence of a crime. But the ODNI's recently declassified semi-annual report, released on December 21st of 2022, reports all kinds of non-compliant searches. These are just the ones we know about, just the ones that the ODNI report was able to identify, involving U.S. persons, including the searches of prospective FBI employees, members of a political party, individuals recommended to participate in the FBI Citizens Academy, journalists, and even a congressman. The politicization of the department is a problem. And you can tell your department, not a chance in hell we're going to be reauthorizing that thing without some major, major reforms. Your department is not trusted because it has been politicized. I know you are a good person. You have the ability to rein it in. I ask that you do so promptly.
Thank you.
I assume you're aware of the overly aggressive arrest and prosecution of Mark Houck, who's a pro-life activist and father of 7 in Philadelphia, based on the fact that he had pushed a protester who, or a Planned Parenthood escort, rather, as he was demonstrating outside of an area in the Philadelphia region. He pushed this person after this person got in the face of his 12-year-old son and was yelling vile, insulting, demeaning, implicitly threatening things, denigrating his father, denigrating his faith, and yelling vile, sexually suggestive things to his 12-year-old son. So he shelved him. And then, before they knew it, Mr. Houck was facing FISA Act prosecutions. A highly militarized group of DOJ law enforcement showed up to enforce a warrant. They showed up at about 7 a.m. on a Friday morning. And as Houck's wife put it, a SWAT team of about 25 came to my house with about 15 vehicles and started pounding on the door, and then had about 5 guns pointed at my husband, myself, and basically my kids. This concerns me. Mr. Houck ended up facing these charges, and not surprisingly, the jury acquitted him of that. I'm just wondering how it doesn't seem justifiable to me to have that overwhelming show of force for conduct like that. in the meantime, in 2022 and for the first couple of months of 2023, DOJ has announced charges against 34 individuals for blocking access to or vandalizing abortion clinics. And there have been over 81 reported attacks on pregnancy centers, 130 attacks on Catholic churches since the leak of the Dobbs decision, and only 2 individuals have been charged. So how do you explain this disparity by reference to anything other than politicization of what's happening there?
The FACE Act applies equally to efforts to damage, blockade clinics, whether whether they are a pregnancy resource center or whether they are an abortion center. It applies equally in both cases, and we apply the law equally. I will say you are quite right. There are many more prosecutions with respect to the blocking of the abortion centers, but that is generally because those actions are taken with photography at the time, during the daylight, and seeing the person who did it is quite easy. Those who are attacking the pregnancy resources centers, which is a horrid thing to do, are doing this at night in the dark. We have put full resources on this. We have put rewards out for this. The Justice Department and the FBI have made outreach to Catholic and other organizations to ask for their help in identifying the people who are doing this. We will prosecute every case against a pregnancy resource center that we can make. But these people who are doing this are clever and are doing it in secret. And I'm convinced that the FBI is trying to find them with urgency.
Okay. See, my time's expired. Mr. Chairman, I'd like to submit for the record a copy of a letter sent by Representative Andy Biggs from Arizona regarding a case involving Philip Esformes, an individual who was granted clemency by the prior administration and who's now apparently being prosecuted. I hope to discuss this in a subsequent round.
Without objection, it'll be entered in the record. After Senator Lee asks, we're going to take a brief intermission. Senator Lee.
Thank you, Attorney General Garland. I want to echo briefly what Senator Klobuchar described. I hope you'll look at our letter and investigate thoroughly those issues. As you know, I've long respected you, and I've long respected your department. I have become concerned recently that notwithstanding the great men and women who serve and have served for generations in the Department of Justice, there are some things that lead me to wonder whether some actions are being politicized within the department. One example of this relates to 18 U.S.C. Section 1507. Ever since the leak of the Dobbs opinion and then the issuance of the Dobbs opinion by the Supreme Court last summer, we've had protesters who have been showing up at the homes of Supreme Court justices, carrying signs, picketing, shouting. It's very clear that they're trying to influence, in one way or another, those serving on the United States Supreme Court, trying to influence jurisprudence. And yet, not one person, to my knowledge, has been prosecuted for such things under 18 U.S.C. Section 1507. About 2 weeks ago, this committee invited some officials from the Department of Justice to brief committee staff on protests at the justices' homes and ask about any arrests that have been made or might be made for people engaged in that behavior. The briefers came to the briefing and informed staff that they hadn't read Section 1507. I assume you've read it, of course. Just wondering why the department would schedule such a briefing on a statute without having read it, and especially why no actions have been brought under Section 1507 for these actions. I've got a lot to cover. Can you answer that?
I'll try to answer all these questions together.
Just tell me, am I right in concluding that you haven't brought any charges under 1507?
So I don't know the answer to that. We have the thing that mattered, and as soon as the Dobbs draft leaked, I ordered the marshals to do something that the United States Marshals had never in history done before, which was protect the justices' homes, residence, and lives 24/7. No Attorney General had ever ordered that before, and no Justice Department had ever done that before.
Which is terrific. That's fantastic.
So I'm getting to the why. So we sent more than 70 U.S. Marshals for this purpose. Those marshals' priority is protection of the lives of the justices and their families. They are on site, but their priority job is protection. That is why when someone did come to assault Justice Kavanaugh, he had to go away from where they were because there were two marshals in front of the house, and eventually he self-reported himself. The marshals have been advised, and they know, the marshals on the ground, they have full authority to arrest people under any federal statute, including that federal statute. But they have to make the determination on the ground whether they can do that in a manner that is safe and able to protect their main mission. Now, there are also state and local entities which have similar authorities, and which I understand the Supreme Court Marshal has asked them to do this as well. I don't know whether they have done any of those things.
Okay, thank you. I'd love to follow up with you more on that later. It is concerning to me when you show up at the home of a public official, you're sending the message of implicit violence. You're sending the message, we know where you sleep. We know where you and your family are most vulnerable, and it's very concerning to me. I'm troubled by a number of things, including some exchanges you had a few minutes ago with a couple of my colleagues, one in particular dealing with your definition of operational control. This wouldn't trouble me quite the same way that it does, but for the fact that this isn't just a casual term of art that people throw around. Nor is it a term that made its first appearance with your service at the Department of Homeland Security. This is a statutorily defined term of art. And Congress has defined it now for the last 17 years as involving the prevention of all unlawful entries into the United States. And so it appears to me that your definition, which has to do with maximizing resources, it distorts this. It appears to me to be something that is perhaps an intentional effort to obfuscate the real problem, to hide the absolute humanitarian and legal disaster that we have unfolding on our southern border, one with massive national security implications and human health implications, as we've seen 110,000 Americans die from fentanyl just last year. All that fentanyl, by the way, comes from Mexico. It's no mystery where it's coming from. It's not made here, not even made in China anymore. The stuff that shows up here, it's made in Mexico. So perhaps this redefinition helps hide that, helps obscure it, but it still doesn't help. Look, this is making it worse. What you're doing is making a lot of things worse. And I'm concerned that this shows up in a number of areas. I'm going to talk about some of those today. Shows up in your use of parole. It shows up on issues related to asylum. And it shows up in issues related to the detention of asylum applicants. Let's talk about parole first. In one of these efforts to disguise the political impact, to diffuse the political impact and disguise what's actually happening, you've started to rename things and rebrand them so that the numbers seem to be improving more than they actually are, but they aren't. It's come to my attention that you've created at least 13 new parole programs within the Department of Homeland Security. Now, I find this odd, because you break them down by things like country of origin, but I find this odd because the statute itself creating parole, which is found in 8 U.S.C. 1182 D5A, says that the Secretary of Homeland Security, subject to certain conditions, may parole into the United States temporarily under such conditions as he may prescribe, only on a case-by-case basis for urgent humanitarian reasons or a significant public benefit, any alien applying for admission to the United States. So Congress went way out of its way to define that and to say this must be handled on a case-by-case basis, no broad grants of these are the kinds of people we're going to parole in. Now, what qualifies as an urgent humanitarian reason or a significant public benefit, in your view, seems to be anything that will appear to reduce regular immigration. This is so far afield from the definition that Congress actually authorized by statute, and far beyond what it's heretofore been understood to do and what the words themselves mean, which is to provide a way that somebody could come in the case of a medical emergency under that portion of the statutory language, or, for example, someone who is coming in under the public benefit prong from a foreign country who's needed to testify in a jury trial or something like that, and then be returned. Parole wasn't intended to be broad, nor was it intended to provide someone a permanent residence or a residence that can become permanent within the United States. And so this is really concerning to me. When we see this, I wonder how you can possibly defend the legality of this. It shows up further in the way that you're handling asylum. Let me ask you this, Mr. Secretary. Does anyone coming into our border have a right to asylum? Or is this rather a grant of discretion to you as the Secretary of Homeland Security to grant it where you deem appropriate, under the circumstances prescribed by the law?
Currently, Senator, we are exercising the public health authority of Title 42, and under Title 42, a claim of asylum cannot be made. The individual is expelled under that public health authority, and irrespective of the fact. So let's put that aside.
I know you want to talk about Title 42. Title 42 is going away in a few weeks.
So then an individual who arrives at our border may claim fear of persecution by reason of their membership in a particular social group.
I get that. I know the standard. I'm asking you, is it a right or is it an act of discretion on your part? Because remember, the language says the Secretary may grant them asylum. May. May is not shall. So is it discretionary or is it mandatory on your part?
We have the ability to make a discretionary decision with respect to the grant of asylum based upon the factors that we evaluate.
Okay. Now,
I have something to say about parole, but perhaps
sure.
the question's not
if we've got time to that, I want to talk about this first. Your exchange with one of my colleagues, I think it may have been Senator Graham earlier, you seem to concede, at least for purposes of discussion, that most asylum applicants don't get in, and that the number may be something like 9 out of 10 who don't get in. I know it varies from country to country, but it's more or less 9 out of 10, or some large number, some large percentage of asylum applicants are not eligible to come in. Is that right?
That is correct. That the number who qualify under the initial threshold of credible fear is larger than the number of individuals who actually ultimately succeed in their final asylum adjudication.
Right. In fact, federal law...
That's purposeful by design of the statutory framework.
Under 8 U.S.C. Section 1225b1, an alien awaiting an asylum determination, a ruling on his or her asylum application, is subject to mandatory detention. It says that the alien shall be detained pending a final determination of credible fear of persecution, and if found not to have such fear, until removed. And yet, you're not currently detaining all asylum applicants, are you?
Senator, I believe this very issue is a subject of ongoing litigation. I will only say this, therefore, that the Department of Homeland Security, specifically Immigration and Customs Enforcement, has never had the detention capacity to detain every asylum seeker.
I'm not asking whether you've got that detention capacity or whether they have in the past. I'm asking what is supposed to happen. And the truth is, under the statutory provision I just read to you, you're supposed to detain them. And yet you don't. And as far as running out of detention capacity, you are, in fact, getting rid of detention space. Are you not, as reported by Fox News just yesterday?
No.
And what about the fact that
No, we're
the
not.
ICE detention budget has been slashed by this administration to the tune of hundreds of millions of dollars?
Senator, we're not reducing the amount of detention space. I don't know to what that report refers. As a matter, I'm not sure what that report refers to. We're not diminishing the amount of detention space right now.
You are not deporting people once you reach your cap of the detention space, and that is a problem. Because you've said time and time again in front of this committee and in other contexts, you and other members of this administration have said over and over again that the system is broken, the process is broken, the law is broken, and then you blame it on Congress. Well, maybe that's good if what you're wanting to do is advocate for some kind of reform that involves amnesty. But it's just not true as far as the asylum process, because if the asylum process were followed by the law, you would turn people away. You would send them back once you ran out of detention space. You'd detain those who you're supposed to detain, and then you'd send the rest back. And this is a big problem. Look, I'm running out of time. I am concerned about a number of things that I'll follow up with questions for the record, but a couple of closing issues, just in short. First, I'm very concerned about your Office of Intelligence and Analysis. There's been a letter sent to you by the House Homeland Security Committee that you have not answered. When they do answer that, I would love to get those answers, those responses, and I would also like a briefing on this in the very near future. We need to know what's in there. Look, at the end of the day, it appears to me that you are not enforcing the law. You are redefining key statutory terms in order to obfuscate the fact that you're not enforcing the law. This is a fireable offense. Your department has spent an enormous amount of money preparing for impeachment proceedings, like $3 million preparing for impeachment proceedings. Could it be perhaps that they know that you have been doing this, that you've been redefining statutory terms, failing to enforce the law? That seems removable to me. Thank you.
Senator, I respectfully disagree with you, and I look forward to the opportunity to addressing your concerns.
Thank you, Senator Lee. Senator Klobuchar.
Thank you very much.
If I can make an announcement. After Senator Klobuchar, there'll be a 10-minute break, so we have a roll call on the floor. Some members may want to take advantage of it now. I'm going to be one of them. Senator Klobuchar.
Now we have Senator Lee.
Thank you, Mr. Chairman. Thanks to each of you for your service and for being here today. Commissioner Christie, I'd like to start with you, if that's all right. I want to talk about permitting reform. This is a topic that's finally become sexy, popular to people on both sides of the aisle, and not a moment too soon. It's gaining some traction, and with good reason. It is encouraging that there is a growing consensus that we need to update our regulations so that we can produce more energy in America and rely less on other countries that have lower environmental standards than we do, and also be in a position to supply more natural gas to other countries that rely on much dirtier forms of electric power generation. But unfortunately, some harmful ideas have made their way into the mix. And some of those ideas would increase consumer costs without providing any benefits. Now, one of those ideas involves spreading the cost of large transmission lines among and between a larger group of electricity ratepayers, of customers. This idea, according to those proposing it, is necessary because it would make it easier for them to build large, long-distance lines to deliver wind and solar power to places like California that suffer frequent power shortages directly attributable to their short-sighted, aggressive, radical climate change policies. Now, in my opinion, it's simply not fair to force ratepayers in states like Utah or Idaho or Wyoming to pay for and otherwise shoulder the burden associated with the costs of the California and the Oregon climate policies. So, Commissioner, should Congress be in the position of socializing the costs of large transmission lines to customers who will never benefit from those lines?
Well, to focus on the transmission instead of the permitting, first of all, I think they're separate issues. I think permitting is the legal authority to move forward with construction, and we have huge problems with court reviews on that, as we all know. On transmission, I think that a transmission line that would not be built but for the public policies of a state or state, the cost should be allocated to the state or state that wants to move forward with the public policy projects. There are really three buckets of projects of transmission. The first are reliability projects, and I think everybody agrees reliability projects need to be built, absolutely. Economic projects are where you solve more congestion costs with a transmission line, and everybody generally agrees you need to build those. The public policy-driven projects are projects that are built, but would not be built but for, and they're primarily state policies. And so if the state policies are driving the projects, and classic example is New Jersey's offshore wind, which is driven purely by New Jersey's policies, then I think most people would say that you shouldn't allocate the cost of New Jersey's policy-driven projects to, for example, in PJM, to consumers in West Virginia. And that's the fundamental principle of let the states that want the policy-driven projects allocate the costs among themselves.
Thank you. That's helpful. Commissioner Danley, let's turn to you. As you're well aware, FERC has a pretty well-defined mission, and it's a mission that the Supreme Court described back in 1976 as involving a job to, quote, encourage the orderly development of plentiful supplies of electricity and natural gas at just and reasonable rates. I've noticed that in recent years, in the last 2.5 years in particular, we've seen the Commission starting to stray from that mission. And while I'm pleased that there's been some progress over the last few months toward reversing that disturbing trend, I remain very concerned about the lingering uncertainty that's there, uncertainty that's been contributed to by past FERC decisions, especially those in the last 2 years, that have a tendency to stifle investment in natural gas pipelines and electricity transmission projects. What should FERC be doing, in your view, to provide more certainty to project investors making risk assessments?
Senator, you are quite correct to be concerned about the regulatory uncertainty. FERC is, at its core, a rate-making agency, and what we should do is make our rate decisions as clear as possible. When tariffs are approved, we need to enforce the terms of the tariff. One of the worst things that the Commission does is constantly grant illegal retroactive waivers to do things like jump queue positions or have deadlines that are relied upon to manage queue processing. We need to have clear and firm rules, and we need to apply them, and we need to set the circumstances of clarity and regulatory certainty that allows a rational allocation of capital. Because the risk premiums now, given the uncertainty regulatorily, are so great that they're stultifying investment in critical infrastructure.
I've got additional questions. We've got a lot of members here, and so I'm not going to take more time. As my time has expired, I'll submit those for the record. Thanks so much for being here.
Thank you, Senator.
Mr. Chairman, I'd note at the outset, I'm concerned by the tone and tenor of this hearing. It feels an awful lot like a political witch hunt, which may be in the process of being aided and abetted by a member of the judiciary. After reading the letters from Senator Whitehouse, the responses from the Administrative Office of the courts, and news articles, this appears certainly like sour grapes, or perhaps some combination of sour grapes and a political witch hunt. We've got people who are trying desperately to make a lot out of something that isn't there. And I'd like to offer into the record, Mr. Chairman, a letter from the Secretary of the Financial Disclosure Committee, indicating that 2 iterations of the committee and 2 subcommittees found that there was no willful violation by Justice Thomas.
May 15th letter?
Yes, this is the May 15th letter. Thank you.
I'm sorry, what letter is that, please? A letter dated May 15th to me from the Honorable Rosalind R. Mouskopf, answering letters that I had sent April 21st, 27th, and May 5th.
Judge Wolf, how was the press and specifically Bloomberg News. Bloomberg News reporter Zoe Tillman able to review your August 2012 letter to a group of Judicial Conference colleagues. How did that happen?
I do not know. She sent me an email asking if I would speak to her, and I communicated that I declined.
Doesn't the timing of this seem a little odd? I mean, this is something that occurred 11 years ago, and days before this hearing, it magically appears. Did you leak a copy of the letter?
No.
To Ms. Tillman? Did you leak it to anyone else who may have given it to Ms. Tillman?
No, and actually, of course, I've thought about that question too, and you'll excuse me if I say something that may be supportive of all of you. I had not given those letters to any senator, any member of his or her staff. The administrative office would have these records.
Who did you give them to?
Nobody.
No one.
Correct. And Mr. Lee, I worked closely with your father when he was the Assistant Attorney General for the Civil Division, and I was Attorney General Levy's liaison to him. I think your father would have been very disturbed by the matters that I've addressed, A, and B, would have engaged, and I would have thought that members of the Senate from both parties would be concerned about whether the judiciary and anybody else was properly
Seriously?
interpreting
You're going to bring up my dad? You're here attacking a member of the United States Supreme Court on grounds that are frivolous, on grounds that have been rejected by two different iterations of the Judicial Committee that you're talking about. Twice rejected, and you have the audacity to come in here and invoke the memory of my late father? It's shame on you, sir. Okay, look, you submit a statement to this committee. It's a lengthy statement. Contains 122 footnotes. On page 2, you state that you're testifying, quote, as an individual and not as a representative of the Judicial Conference of the United States or the federal judiciary, close quote. Did your law clerks help you draft this?
Yes.
Who else helped you draft it? Who else was involved in the drafting of it?
Just my law clerks, although I did consult one of my colleagues about it.
Okay, so you're not here on behalf of the conference, and yet you used judicial resources to do it, and you consulted one of your colleagues to do it, and you're speaking solely in your capacity as someone who served on the committee, and so you're purporting to speak for the committee.
No, I'm not. I said I'm speaking. When I was invited first to be interviewed, I thought by Senator Kennedy, who declined to meet with me, but I did meet with his staff. And then when I was invited to testify, I immediately informed the Administrative Office of United States Courts. I was familiar with the guidance, again, not public. The judges are free to speak. The Canon 4, as you saw when you read my piece, encourages judges to speak on matters relating to the administration of justice when they have experience or expertise. And the only thing that the administrative office said to me was, be sure to point out that you're testifying as an individual, which I had already done in what I was drafting. And if I wanted any ethical guidance, it mentioned who to call.
Okay.
But
Senator
canons,
Durbin?
I'm sorry, are vividly clear, and there wasn't any open issue on which to consult.
Yeah.
Senator
And
Durbin.
yet you're here speaking in that capacity based on your service on that committee, notwithstanding the fact that your motion to have it considered by the full conference as to your suggestion that Justice Thomas's disclosures were willfully wrong was rejected.
Senator Durbin.
Judge Wolf, Senator Lee.
Over the past 12 and a half years, I've raised significant concerns in hearing after hearing after hearing about FISA and the FBI's shocking disregard for Americans' constitutional rights and civil liberties. I've been given basically the same answer by FBI directors and attorneys general and other officials during 3 presidential administrations involving both major political parties. The answer every time is a variation, more or less, of the following. Just trust us. Don't worry. We've got good people, law-abiding people running this, and we've got lots and lots of procedural safeguards in place to prevent this type of abuse that you're facing here. These aren't the droids you're looking for. That's what we're told. Here again today, just the last 24 hours, we got a new policy. This one's finally going to fix it, you tell us. This one's going to do it. Meanwhile, what's happened? Well, in 2019, Inspector General Horowitz issued a shocking report confirming a lot of what I had feared over the years, but had found it difficult to prove. A report regarding Crossfire Hurricane, the FBI's secret surveillance of Donald Trump's 2016 presidential campaign. And then a subsequent memorandum dealing with the FBI's failure to maintain these so-called Woods files, which Woods file is basically the evidentiary record underlying a FISA order request in violation of FBI policy. Year after year, and hearing after hearing, we hear of instances of noncompliance, including the disclosure just last month that the FBI illegally surveilled 19,000 donors to a congressional campaign. Americans participating in protests in the summer of 2020. Americans who were in Washington, D.C. on January 6, 2021, and even a sitting member of Congress. Hundreds of thousands of searches of Americans' private communications and information are conducted each and every year without a probable cause warrant. Frankly, without any warrant if conducted under Section 702. Now, let me be very clear. That number should not just be going down. That number should be 0. Every quote-unquote non-compliant search involving U.S. persons violates an American citizen's constitutional rights. And yet every year, the FBI claims that we should just trust the FBI to fix the problems internally. Well, first they tell us there are no problems. Then they tell us we will fix them because we've got good people and we've got new policies. At this time it's going to be different. Only later we find out that the FBI conducted more and more illegal searches in violation of Americans' constitutional rights than the last time we addressed the issue. So it's hard not to conclude that the only thing the FBI wishes it could fix here is the possibility of getting caught. This is what I find so insufferable. This is what I find so incredibly insulting. Look, I want to echo Senator Blumenthal's point a minute ago, and I hope every American can take note of this feature of this. This is unlike other court proceedings. We call it a court, and yet it doesn't have any of the trappings of an ordinary court. There is no adversarial process. We're told a moment ago by Mr. Olson that it's okay. It's okay because the FISA court has the ability to appoint an amicus anytime it feels necessary to do so. Well, why not in every case? And even if there is an amicus, what interest does the amicus have that's on par with the individuals affected? The bottom line is you collect all this data, and then after you store all that data, some of it involving communications, the content of individual phone calls, emails, text messages, whatever it is, the content, not just the metadata, but the content. You can do a backdoor search on that without a warrant predicated on probable cause. That is itself an affront to the Constitution. That is itself something that is always going to lead to constitutional violations, and it must stop. We've got an opportunity this year to make necessary reforms, and we must do it. But while we've got you here, Mr. Olson and Mr. Abate, why should we ever trust the FBI and the DOJ when it comes to this issue, whether under the current administration or under a future leadership? Why should we ever trust the FBI and the DOJ, again, to police themselves under FISA when they've shown us repeatedly for more than a decade that they cannot be trusted to do so?
Senator, thank you for the question. Obviously, Section 702 is an invaluable intelligence tool. That's beyond dispute. It's also one that's very powerful, and it must be used responsibly. And I share the frustration that you express with the lack of compliance that we've seen in past years from the FBI. I'm not here to defend those compliance problems. What I can tell you is that those compliance problems predate some of the very significant changes that the FBI has put in place. I will not say that compliance problems will be zero next year. We are not saying, as I think you mentioned, that we say we're done. This is an ongoing process. We will continue to try to improve. We will work with you and your staff and other members of Congress to make sure that we're implementing procedures and policies, training, and other measures to continue to drive down these errors and compliance problems. But in the end, the tool itself is so incredibly important to our national security that I believe that its essential effectiveness must be preserved.
Mr. Abadi?
Senator, thank you. I share your concerns as well, and I take this seriously. And with regard to the FISA 702, since I've been in this role and under the leadership of Director Wray, we've made significant changes, ones that have never been made before, and there has been a lot of progress, but we're not going to rest on our laurels. We're going to keep driving ahead, continue to implement reforms as required, taking guidance and counsel from the committee and other members. With regard to Crossfire Hurricane, what happened there was wholly unacceptable. We agree with the findings set forth by Inspector General Horowitz and Special Counsel Durham. We've acknowledged that in the past, and that's 2017 and earlier that conduct occurred, not under Director Wray's leadership or when I was in this position. We have an entirely new leadership team. We've implemented very strong corrective actions, the poor decision-making, the grave errors of judgment, the misconduct, the lack of rigor investigatively that occurred there, totally unacceptable. We reject it. We hold people accountable for that now. And everything that we've done on the work, on the mission since that time, we've worked to avoid those mistakes and apply the lessons learned of the past. And anyone we find who goes against that, they are not going to work in the FBI and they will be held accountable for that period.
Great to know. Congress has got to fix this problem and stop trusting the surveillance state to fix it. It can't, it won't. We know that because it hasn't.
Thank you, Senator Lee. Senator Hirono.
Thank you, Mr. Chairman. Mr. Chairman, I share your concerns about the...
Thank you, Senator Whitehouse. Senator Lee.
Thank you, Mr. Chairman. Thank you, Ms. Peters, for being here and for your service.
Thank you, Senator.
Nearly 1 year ago, we held a hearing. I think we're 2 weeks shy of being 1 year from that hearing. Immediately following that hearing, I submitted a short list of questions to you and have not yet received a response. It was during that hearing that a couple of my colleagues asked you about timely responses to questions from this committee, and you acknowledged that it was important to do that. Can you tell me why you haven't responded to my questions yet? These are not difficult questions, and most of our nominees respond within a week or so of getting them.
Thank you, Senator. So I, too, am disappointed that those questions, for the record, have not yet been answered. We have been working on them diligently over the last year. It has been a lot of back and forth with the department. I was hoping that they would be cleared this week. They're not yet. That being said, we have done other things. We've increased the number of employees in our legislative affairs, so the individual requests that we have received over the last year.
Can you tell me when I can receive a response to those questions?
I don't have a specific date for you, Senator, but I know we're working on them.
Okay, I'd appreciate it if you could get back to me by the end of this month. That would be 1 year from the date of the hearing, and I don't think that's too much to ask. One of the reasons I'm asking about this, and I hate to pester you on that, it's just we do need answers to those questions. They're important. Among the questions that have been asked of you relate to how we separate out male and female prisoners. We do this for good reasons, reasons that relate to human biology, differences between the sexes, and there are a lot of questions that we have about how we do this. It's quite concerning that the number of female inmates who have become pregnant during the course of their confinement in BOP custody is not zero. And it's even more concerning that a substantial number of those pregnancies are the result of the BOP forcing female prisoners to share their facilities with biologically male prisoners. It's really concerning. Now, in January of 2022, the Bureau of Prisons adopted definitions that have an impact in the area that I'm asking about. Definitions for words like gender, gender nonconforming, gender affirming, and cisgender. For example, the Bureau of Prisons must now look at gender as, quote, a construct used to classify a person as male, female, both, or neither. Gender encompasses aspects of social identity, psychological identity, and human behavior, close quote. Now, I understand there are lots of feelings, lots of different beliefs about those things. But what I find most alarming about this is that notably absent from that list are things that you might expect to see, that you might think should at least be taken into account. Things like biological sex, like reproductive organs, the presence of a Y chromosome, or something as simple as a 5 o'clock shadow or an Adam's apple. Is biology now a verboten subject when you determine which prison you're going to send a prisoner to be incarcerated in? Is that now off limits?
No, Senator. In fact, I would present to you today that the majority of those in our care and custody are housed in facilities based on their chromosomal distinctions.
The majority of them, as we've always done, and as any sane prison system always would. The majority of them, that's good to know. But why not all of them? Why would you ever subject female inmates in particular, who face a series of biological disadvantages relative to male prisoners, face a number of vulnerabilities that male prisoners don't face? Why would you ever subject female inmates to being incarcerated against their will with biologically male prisoners? Can you tell me when that's ever justified?
So we also recognize, as do many experts, that a person may identify as a different gender than their biological one, and we recognize that at the Federal Bureau of Prisons.
Okay, but a prisoner, as I understand it, need only convince a single Bureau of Prisons psychologist to sign a form to have their identity considered for a transfer. Just one person. And the request then has to be approved, but that's really all that has to happen. It's almost a turnkey situation. They convince one psychologist and the whole process is set in motion. And yet, it's my understanding that BOP doesn't publish statistics on the number of inmates who are assigned to a prison that doesn't conform with their biological sex. Why is that?
So, Senator, while that frontline counselor starts the process is very complex. It's a multidisciplinary team that includes experts from psychology and health services and corrections that make that final determination around
So why
housing.
doesn't it publish the statistics?
Senator, I don't know why we don't publish the statistics, but I can look into that and
Okay,
get back to you.
that would be great. If you would publish that, I would appreciate it. Now, some have estimated that the number is around 1,300 as of January 2022. To the extent that that estimate was even in the ballpark, it's undoubtedly higher now, the longer that this stays intact. That is not an insubstantial number, especially when you consider the fact that most prisoners in America are not in BOP custody. That is, most prisoners are serving a sentence issued by a state court for an offense under state law, not federal. It's a really large number, and it's very concerning considering the number of pregnancies that take place, the number of heinous circumstances that can result from this, and in fact have resulted from them. I see my time has expired. I've got other questions to ask you on this and other topics, including implementation of the First Step Act. I will submit those in writing. Thank you.
Thank you, Senator.
Senator Curtin.
Thank you, Mr. Chairman. Thanks to all of you for being here. Ms. Dunn-Marcos, I'd like to start with you. And I've got a lot of material to cover, so if possible, I'd like to have you confine your answers to yes or no, if possible. So let me summarize some of what I understand about this process, about the ORR process. Now, once you get a child, you start looking for a sponsor, or alternatively, a sponsor may come to you. And then you do some kind of a precursory background check to figure out what's going on, to see if they've got any convictions in the United States. You don't ask if the sponsor is here legally. You don't check in the sponsor's home country if the person is not originally from the United States. to see if they are wanted there for a crime or have been convicted there of a crime. You don't come with local law enforcement. You seldom, if ever, do any kind of a home visit. If they don't answer the phone after a month or so, then you consider your job done. Given that you cannot remove a child once you've placed her with a sponsor, wouldn't you agree that vetting on the front end should be increasingly more vigorous and not less? And shouldn't a home visit and conferring with local law enforcement be the bare minimum that is done rather than the entirety of what you do?
Thank you for those questions, Senator. I think that we have thorough vetting processes in place. We have child welfare experts throughout the country. We believe a child is best in a family, with a family in a community, not in a congregate care setting.
I don't doubt that. I don't doubt that. But given what you don't do, that's what I find alarming. I don't doubt that you do some things, but what you don't do is alarming. And that's why it shouldn't be surprising to us. This New York Times article that my colleague Senator Cornyn referred to, that indicating that HHS has lost contact altogether with more than 85,000 children. 85,000 children that this administration has negligently placed with all but unknown sponsors, and now ORR has no earthly idea where these children are. And when asked about this, you recently passed the buck entirely and said, aside from the 30 to 37-day follow-up call, you, quote, do not monitor or track the whereabouts of children after they're released from your care, close quote. So am I understanding this correctly, that they're not lost because you're not legally responsible to know where any of them are after you place them, yes or no?
Thank you, Senator. I want to clarify that ORR is not a law enforcement agency or an investigative agency.
I don't doubt that. I'm not accusing you of that. I'm saying you don't know where they are, and now you're disclaiming responsibility. And of the 430,000 unaccompanied children, the vulnerable unaccompanied children who have crossed over our border in the last 34 months since President Biden took office, what percentage of those children's whereabouts can you tell me with any degree of certainty?
Senator, respectfully, I want to state again that it is not accurate to say we have lost, that we have lost them.
Okay, what about my question? What percentage can you tell us where they are?
I don't have those figures directly in front of me, but what
Will you
I
get
can
those to
tell
us?
you, I will take that back
Okay,
to the team. But
let me tell you what's happening to them. Because clearly, you either don't know or you're not saying. They're being trafficked for sex. Doctors Without Borders has repeatedly told us that at a minimum, 30% of the young women and of the children who make this dangerous trek across our southern border, to it and then across it, are sexually abused on their journey. There are other entities that have come up with much higher estimates, some of them double that or more. Can you give us any idea how many of the 430,000 children who have entered our country under the Biden administration have been trafficked either en route or after they leave your care? Any idea at all? Any rough estimate at all? Any approximation of how many of them?
Senator, one is one too many. I don't have those numbers in front of me, but anytime we have a flag for a child in our care, we make a referral. Within 24 hours, we are referring to appropriate authorities, HSI, our Office for Trafficking in Persons. If we really want to change this narrative, we want to provide post-release services and legal services to every child. Thank you.
My time's expired, but look, the sheer volume of this, coupled with the estimates that I've never heard you refute, are that we're talking about probably hundreds of thousands of them who have been trafficked for sex and who have been sexually abused. This is wrong. It's wrong that we set up a system that encourages and then allows and then promotes and perpetuates this process that enriches drug cartels and does so at the expense of child sex trafficking, and it must end. Thank you.